Everybody's ready. The appellant in this case, I believe Mr. Lantz will be arguing.
Thank you, Your Honor. Madam Chief Justice, Your Honors, may it please the court, Ms. Rabe. First, I'd like to thank the court and the court staff for making an interpretive service available for Mr. Carreras, who is in the courtroom.
By the way, I knew that and I forgot to make a note of it. Where is the interpreter? Okay, do you need to be seated somewhere differently, or is this okay with you?
Your Honor, this is fine with me.
Okay. And same with your client? Okay. All right, thank you. I'm sorry, I meant to address that and I forgot.
Your Honor, I wanted to express our appreciation for court staff's effort in that regard. This appeal requires the court to address two important topics related to a licensing statute for motor vehicle dealers. First, what is the ordinary meaning of the phrase, three-word phrase, in connection with, in the context of that statute? And relatedly, how do we determine the ordinary meaning of that phrase? A second topic I think this court must confront is, what is the limiting principle of the DOT's interpretation of that licensing statute? The DOT's approach in this case has been outcome-driven. It chose an outcome, which was revocation of a dealer license here, and backed into its interpretation, rather than starting with the meaning of the phrase in the first place. The first jurist in this case to really confront the interpretive issue was the administrative law judge that was assigned to this case before the final agency action. And the proposed decision issued by that administrative judge thoughtfully evaluated and examined how this phrase, in connection with, is different from other dictionary definitions of connection, and looked at how it's used in various contexts, a very thoughtful decision, and ultimately disagreed with the DOT's authority that it was acting upon in this case. Then, in the final agency action, the DOT reversed that administrative law judge, but even in the final ruling, did not even express an interpretation of the statute that it was acting upon. The DOT's interpretation evolved as we got to the district court into two basic ideas. One was that relating to is synonymous with in connection with, and that was their view. The other was a but-for causation test. The idea being that a conviction is in connection with motor vehicle sales if the criminal conduct could not have occurred factually but for the vehicle sales occurring. These interpretations we have submitted are problematic for a variety of reasons, and I'll hit on a few. The first is that the DOT's interpretation and position in this case is not really based on a definition of the operational phrase, in connection with. The Court of Appeals and the DOT have cited to definitions of nexus and connection, but we know that that phrase, in connection with, is different in its meaning, has a different meaning than just connection itself. We know that because of how those phrases are used. The ALJ's opinion, it's on pages 30 and 31 of our appendix, walked through the different ways that factually he and Mr. Carreras are connected. They have a factual link together, but that no one would say they were in connection with each other. We are all connected here today by virtue of our participation in this oral argument, but we wouldn't say that we are participating in connection with one another. Ms. Rabe and I have had a connection to each other by virtue of this case since 2019, but I would not say I'm working on this case in connection with her. Yes.
Appropriate to say that Mr. Carreras was convicted of structuring in connection with selling cars? You're saying that that's not a proper construction?
Correct. In many contexts, courts have actually recognized in securities contexts, in criminal law contexts, that the phrase in connection with, when we made this statement in our brief, I think, citing a case called Wyatt, that the phrase in connection with it, the meaning of it is not self-evident or obvious. I think the point of that was that there must be context given to how that three-word phrase is used. It's not the same in all contexts.
So how would you then construe the statute in a way that's workable?
Interpretation is the correct one. The one that he had his aha moment, as he put it, from the Lexico dictionary definition that is consistent with other conventions of usage, that is with respect to or concerning. So the conviction he pointed to a common usage, and in his opinion, his definition was the only one that's actually of this phrase, from a definition that tries to tackle difficult interpretive challenges, I think. But the convention that he pointed to is many instances where people say somebody was convicted of X in connection with Y. And as he pointed to, the X is the crime, Y is a plain statement of the facts, and in connection with the definition there fits when you say, was this concerning? The issue is that structuring itself is agnostic when it comes to the source of the money. Structuring currency deposits, it does not matter if it's from something legal, illegal. It's a crime because it's a banking offense. Yes.
That the funds were placed into the corporate bank accounts at these different banks. In other words, I think that they were the motor vehicle business accounts in each instance, right?
True factually. There is a factual link. We won't dispute that there is a link between them, but for the legal question here of whether that makes the conviction in connection with motor vehicle sales or other activity relating to motor vehicle sales, I think that is not a sufficient and meaningful link to, given the definition of in connection with.
Kind of mean connect?
Our position is that a link itself, a connection, is not how this statute is written. The statute could have been written, as many license revocation statutes are, that if there is a conviction relating to motor vehicles, that we would have very little leg to stand on if that's how the legislature wrote this. But that's not how they wrote it. They chose, and in fact, we've listed almost a page full of other cases in revocation statutes.
And it was a federal crime. If you had the same set of facts, couldn't they be charged under Iowa's fraudulent practice 714.8?
I believe they could. I don't.
Makes any entry or any record of any business enterprise knowing the same to be false. I looked at the documents that were submitted as part of the administrative proceeding, and I think it is considered, it's the Department of Justice's, it's Exhibit C. They talk about of course they had some linking. Agents West and Thompson did an initial review, and they collected all pertinent documents to support their allegations of structuring and referred to the different, they had to write a piece of paper. I'm giving this bank $4,000 and that bank $8,000. That isn't that an entry for a business known to be false?
Known to be false in the sense that they did deposit those funds. What made this makes it a crime is that people are breaking down multiple deposits that could be deposited at more than $10,000, the purpose being to evade a federal reporting requirement. There's nothing fraudulent.
According to that code section that is at issue, we've all jumped to the middle part of 322.3 sub 12. But the very beginning of it talks about a fraudulent practice, doesn't say a state fraudulent practice, doesn't say a federal fraudulent practice, doesn't define it, and then it gives other state examples. So wouldn't it be reasonable to assume that that is intended to be kind of open-ended and that they're trying to wrap everything up as far as what could be considered this type of activity?
To break this down, the fraudulent practice certainly is one trigger in there. That is a defined term in Iowa law. I think the definition of and the types of different triggers that precede the catch-all phrase provide a limit on the catch-all phrase. And so that is the as generis canon of construction, bringing my Latin in here. I think the issue, though, as to this particular, I don't think any of the facts of this case would support a fraudulent practice offense, and it was, of course, never charged that way. But this is not a crime of where there is an intent to deceive, an intent to defraud anyone. It is something that is wrong because it's illegal, not wrong because it's wrong. And it is wrong in the sense that, look, the Court of Appeals got this issue wrong. They believed that it was the reporting obligation of Mr. Carreras. It was not. It was the bank's reporting obligation. Mr. Carreras and Mrs. Carreras did not make any representations as to as to what they were filing with the IRS. They reported this information on their taxes, in fact. So this, in terms of the income, this is not a deceptive action. And in fact, the evidence showed, as it does in many structuring cases, that bank employees knew about the structuring practice.
I kind of struggle with this distinction between in connection with and connected, because at some point it really just seems kind of like an assertion. Like, you know, you say, well, this is not in connection with, it's connected. They say the opposite. It seems like the real issue, or at least what I'm struggling with, is that the offense is, I think you described it maybe as agnostic. Like the offense conduct itself, but for this federal structuring law, is really kind of a nothing burger, right? I mean, let's just be blunt, at least in my view, that's the real problem, is you have this kind of bogus structuring charge, and now it has collateral consequences, and that's really what the issue is, and it's whether or not, in terms of the purpose of this statute, was it really meant to deal with this versus fraud and deceit, right? I mean, it's more of a purpose question, not a connection or causation question.
An issue, we've certainly raised that as well. And we routinely deal in our criminal defense practice, and I know this court sees cases with much, and crimes with much higher mental state requirements than what are required under the structuring offense under federal law. The agnostic point is that the crime does not concern this original source of the money. I do think, though, there is a textual question, about a fundamental question about how we interpret this statute and what consequences that may have for other cases, many of which use in connection with, which I think this case can be limited to this context, and that's important. Part of the problem, as we pointed out, is we think the Miller versus Cuddy's case is being warped in different ways. But the other point I'll raise as to the textual issue is an absurd results issue. This is the limiting principle question. If we've raised this hypothetical criminal convictions in our briefs of what if somebody uses proceeds from vehicle sales and goes and buys a weapon and shoots an endangered species, or uses those proceeds and in the administration of their business doesn't pay people what they're supposed to in a way that's criminal, an IRA violation. All federal crimes we have been involved in, actually. We proposed these to the district court, and there's no one pressed anyone on it. Finally, the first time anyone's forced the DOT to address these was the Court of Appeals, and Judge Ahlers asked the DOT, your interpretation really isn't that broad, is it? And surprisingly, the DOT said yes. It actually is. It captures anything that would result.
At least in this case, the criminal conduct is actually the use of the money in the business, right? The funds were deposited into the business account, and the way they were deposited in and of itself is illegal under federal law, which is different than using the money to purchase a gun and commit a murder.
It's not really the use of the funds that is what triggered this crime. It's the manner in which they were deposited, right? So, which is a slight nuance there, but no one actually says that it was a problem. And if this were some form of money laundering conviction, it might be different, but.
Were part of the business operation. I mean, this was a business activity, depositing funds into a business account, right?
But there is no limiting principle on the DOT's interpretation to exclude the other cases that, and hypothetical examples I discussed, because under the DOT's interpretation, all that's required.
It's that when they go back into the bank, they come back out and are used for car-related sales, right? I mean, it's one thing I get if you took the funds and bought drugs with it or bought weapons with it or did something else with it, and then it's out. But it seems to me that there's this sort of placing back into the flow associating with sales of vehicles. And that's kind of where I'm getting stuck on this.
It didn't concern any of that, right? It didn't require any element of proof related to the use of the funds after the deposits occurred. That's
Right?
in terms of finding the interpretation of this statute, this court should look at what is the limiting principle that guides how this statute can be interpreted.
Is that the money came from the sale of cars, so isn't that in connection with?
Too broad of an interpretation of in connection with. I see my time is up for this section. Unless there's further questions right now, I'll wait for my rebuttal. Thank you.
May it please the court, counsel. If I heard Mr. Lantz's argument correctly at the outset, I'm already off of my outline here. He said if the statute had a provision that said related to motor vehicles, or he may have said related to motor vehicle sales, that we wouldn't be here today, that there wouldn't be a question. And in fact, 322.312, that's exactly what it says. It says there's a 5-year ban from being a dealer for fraudulent practice or any other indictable offense in connection with selling or other activity related to motor vehicles. Petitioner's argument has you looking at the sale of a motor vehicle almost in a vacuum, as in someone hands you the money and they take the car and it's over. And that's not what running a dealership entails. There's a business aspect to it, of course. There's employees, licensing regulations. There's all the things you have to do, to get it registered and comply with the fees, and you're working with the county, and it's a business. It doesn't end when the person hands you the money and drives away. I mean, as a practical matter, there's follow-up even with the customer. There may be service work. There may be,
Draw the line. What is the limiting principle that separates kind of post-business conduct with conduct in connection with the sale?
Extremely fact-specific depending on the situation. And I think that's true in many areas of statutory construction. I know this court has held that in the past. You have to look at the facts surrounding the incident, or in this case, the crime, and make that determination. And that authority under Chapter 322 is vested with the Iowa Department of Transportation. I think it requires a common sense, fact-based approach. And I know petitioner has thrown out different scenarios of like the Endangered Species Act or this or that, and I think you can do that all day long, but until the situation actually occurs and you're faced with it, you can't say whether or not this applies. I mean, we need to step back a little bit and look here at the fact that petitioners were originally indicted on 8 counts of federal financial crimes after a very, very lengthy multi-agency investigation, which is the original excuse me.
It's convicted, right? I mean, that's sort of the key word. So whatever they're charged with doesn't really have any bearing here, does it?
Conviction, it's the conviction that triggers the action under 322.312, but I think in response to the nothing burger discussion that we had, I think we're not just looking at the facts are the facts. We're not just looking at a one-time thing where the petitioner went into a bank and deposited less than $10,000 and that triggered the investigation and the conviction.
Well, except that they were only convicted of 1 count.
We're only convicted of 1 count.
Focuses on is conviction. So so the statute is focused on revoking a license for very specific things, whether they've been convicted of a fraudulent practice, convicted of very specific vehicle violations related to the VIN numbers, convicted of violations related to use of a dealer license. And then there's this catch-all, any other indictable offense in connection with selling or other activity related to motor vehicles. Do you read that catch-all as being expansive or as limiting so that the other indictable offenses are are still related to these other things that the legislature has determined are sufficient to require the license to be suspended.
Being expansive, the DOT's position is it is expansive, particularly when read in connection with 322A 15.1, which says the entire chapter is to be liberally construed in favor of public protection.
That's what I was going to ask you. So the basis of your expansive reading is the general provision that says that the whole chapter is supposed to be liberally construed.
Read that together with the fact that, to me, the legislature has set out those specific things that you mentioned, and then added, any other conviction for something connected or related to selling or related to motor vehicles.
In statute, it says the chapter should be liberally construed to prohibit fraud in the sale, barter, or disposition of motor vehicles. So at least there's an argument that could be made that that's, in one sense, limiting, right? That the purpose here is to prevent consumer fraud and consumer harm. And if that's true, how does this conviction dovetail with that reading?
Also just be preventing general fraud. And I think when you are,
In the sale, barter, or disposition.
but when you are taking the proceeds from the sale, which the DOT's position is, that is part of the sale, the proceeds you receive and what you do with them afterwards, when you dispose of them in a fraudulent manner or as part of a fraudulent scheme, or in this case, I think the Court of Appeals called it evasive, I think you've met that.
To the consumer from this transaction.
There's probably no direct harm to the consumer that we know of under the facts of this case, because the statute isn't limited to consumer harm. And the Court of Appeals pointed that out, and the DOT's position is that is a correct interpretation, that statute isn't entirely directed at consumer harm, because where's the consumer harm in the other four prongs of the statute that were pointed out? I mean, you sell a vehicle with an altered VIN. If you've done a good job and the consumer never knows they have an altered VIN, and they drive that car for its 5-year life expectancy with an altered VIN, they haven't been harmed. They got a running car that they're paying for.
Back to me, like related to fraud in the sale of motor vehicles, right? That you don't want altered VINs, so that way you can check the title to make sure the car is in the legal possession of the dealer and can be sold, won't be impounded or taken from the consumer. The second section relates to the fraudulent use of vehicle registration. So all of these statutes or provisions relate to fraud. And then the construction statute says construe this chapter to present consumer fraud. So I don't follow really.
Altering VINs or misusing your dealer license by maybe allowing unauthorized people to use it or something of that nature, I don't view that as a bright line difference from taking your vehicle proceeds from your dealership and misrepresenting to the IRS or whatever agency, to the bank, through your reporting requirements, that you are.
There, because your opposing counsel said that it wasn't their reporting requirements, it was the bank's reporting requirements. So it's not the fact that they misrepresented anything to the bank or to the IRS. The structuring crime was just that they took deposits that were over $10,000 and split them up into smaller amounts.
The factual basis for the plea, they admitted they knowingly split up deposits into their 3 business accounts over a period of more than 3 years.
The splitting of deposits. I just wanted to make the point that it's not that they misrepresented anything to the IRS or to the bank. Or, I'm sorry, that they made that they had a reporting requirement that they didn't meet, because they did not have a reporting requirement, right?
They knowingly structured the deposits in such a way to avoid triggering the bank's reporting requirement.
Could you address the standard of review? Is this a straight-up legal issue that we get first crack at, or are we more deferential that it's application of law to fact where the DOT's, you have to be irrational, wholly, et cetera, which is it?
Standard to review here would be what the Court of Appeals noted, that we are correcting for errors of law while also giving deference. The Court of Appeals did note they would give deference to the agency's factual findings that sort of underpin the agency action because the agency is vested with that authority under Chapter 322.
The tolling of the 5 years, if somebody appeals and ultimately loses and the district court grants a stay, should the 5 years run from the date of conviction and then they're operating well within that 5-year period, or does the clock start again, so it may be more than 5 years from the conviction?
DOT's position and the district court agreed, but then, as I'm sure you all know, that was reversed by the Court of Appeals, that it would, as a practical matter, be told to avoid the absurd result such that we are almost bumping into here, where we have a conviction date from September of 2018. The 5-year ban will run next year, and because of the lengthy appeals that have taken us to this stage, the petitioners continue to stay in business, and there has been no remedial action on the license.
Been, other than that first stage, have been by the car dealer, correct?
All been sought by the car dealer beyond the initial automatic stay, and the DOT has opposed those at every stage. And then when an the last stay that was requested, which was after the district court issued their opinion on the merits of the case, that's when once again I argued at the district court that we have made this statute basically meaningless and made the issue almost moot by the fact that we're running up against the 5-year, and there has been no revocation of the petitioner's license. And I know I believe it was Judge Bauer at the Court of Appeals during oral argument made the point that allows someone, even if the appeal was entirely frivolous, which I'm not asserting here, but it would put someone in a situation where they could file frivolous appeal after frivolous appeal, knowing that even a dismissed appeal is going to take some time to work its way through the courts, and they can avoid the penalty altogether. So, the DOT is very much aware of the language of the statute and how what it says about the 5 years from date of conviction, but I think common sense interpretation to that says that when the enforcement period is told at the petitioner's request over the agency's objection, that it doesn't make sense for them to avoid the entire license sanction in that manner, just as it wouldn't make sense for any other professional regulation.
The legislature knows that these processes can take a while to sort of play out. I mean, isn't it their job to figure out if they're going to give us a particular date that it starts? They could say, from the date of that appeals end or something like that, right? I mean, is it our job to sort of rewrite that?
I can only, theorize what may have happened at that stage and why they did or did not consider this scenario. I'm certain it's hard when you're passing the bill or any new statute and then looking back at the Administrative Procedure Act and trying to see how it would all work together. But I think ultimately this court certainly has the authority to avoid what we call the absurd legislative result. And I think that's what happens in this case with the tolling of the entire period, basically.
The plain language of the statute, 5 years from conviction, but it is a fair interpretation of that means that they're revoked unless and until they reverse the conviction on appeal or they persuade the district court to put things on hold. And once they do that, it's maybe like invited error. They asked for it, they got it put on hold, And once that hold is lifted, the 5 years runs from then. So 5 years from our opinion that resolves the appeal. Is that the DOT's position?
It would run, 5 years from the date when the DOT when the appellate process has been exhausted and there's a ruling that says either the offense was in connection with or related to motor vehicles, and so it stands, or would go the other way in petitioner's favor. And then the 5 years would, because at that point, the petitioner would be out of options to seek a stay. And I see I have 12 seconds left, so I don't have anything further unless there's other questions. Thank you very much.
Mr. Lantz.
Thank you, Your Honor. The primary issue in this case is a legal question about the meaning of 322.3 sub 12. That legal the meaning of that statute does not change case by case. When asked about what is the limiting principle for the DOT's interpretation, it was a non-answer, because to say that this is fact specific, that's not how statutory interpretation works. This law was written with specific language in mind, and we think this is a red flag as to why the DOT's interpretation sweeps too broadly, and why the court should interpret in connection with, in that phrase, in the context of this particular statute, more narrowly. It is also supported, we think, actually, by the Miller versus Cuddy's Camping Club case, which is cited in every ruling up to this point. In that case, it was a consumer fraud statute where the court outlined two distinct lines of inquiry, two distinct branches of consumer fraud, one for fraud and deception, one for unfair practices. And the court said for fraud and deception type problems that the offending conduct needs to precipitate, it needs to be in advance of a transaction to influence the transaction. Whereas what they were dealing with in that case was the unfair practice after the sale and after the transaction. Here, we have something that resembles the first type of problem that the Cuddy's court encountered, which is we know that Chapter 322 is aimed at consumer fraud and deception. This court said that in the Minor case in 1983. We know that because that's the nature of all of the other problems that trigger a revocation. But according to the Cuddy's opinion, then the way that you deal and the way that the type of conduct that is triggering for a consumer fraud problem of the consumer fraud and deception variety is it has to be precipitating. This gets very similar then here to say, we ask the question, did any of the structuring conduct benefit this business or affect their motor vehicle sale at all? No, it's unquestionable.
To 322.15 and the liberal construction.
The liberal construction is still limited by the plain and ordinary language of this statute and the words the legislature used. In fact, there are plenty of quotes from in 2011, Justice Apple wrote that the rule of liberal construction does not provide reviewing courts a license to rewrite the terms of a statute. Justice Waterman wrote a similar thing in 2014. The same is true for this statute.
Part of the liberal construction statute that says to the end to prevent irresponsible, unreliable, or dishonest persons may be prevented from engaging in the business of selling.
That section of it, in terms of an objective, does not, again, allow the DOT to distort the plain and ordinary meaning of the phrase in the operative statute, the revocation, what is triggering the revocation here, based on.
Though, counsel, with respect to that catch-all phrase at the end being an expansive versus a contracting limitation.
I think there are other statutes of it. That liberal construction statute does not cause the court to disregard other interpretive guidance that is well established and common usage of meaning, or common usage of phrases, excuse me, and in particular and definitional issues as well. So there is no other definition of in connection with that is of that entire phrase. We think the revocation here can stand only if the prior conviction was in connection with selling or other activity related to motor vehicles. I'd also add that the DOT's action in this case doesn't exclude someone who was irresponsible, unreliable, or dishonest. There's no indication, there's no allegation, and there wasn't a guilty plea to dishonesty or any history of discipline or sanction. The administrative record here showed that Jesus Carreras sold over 3,000 vehicles in about a 15, 16-year period.
About the specific offense, whether or not structuring might be the type of offense that might represent something being irresponsible or unreliable.
And I think this case shows that that wouldn't be the case in terms of the DOT making that judgment, but virtually at its heart, this case requires the court to.
Before you go there, and before the time runs up, you never asked for a waiver. You asked for a stay. You asked for a stay until the court fully resolves. Doesn't stay mean pause? I mean, it seems a little bit tricky to say, we want to stay, put it on hold, they need this money to support themselves. And then when it's all done, say, oh, the clock was ticking the whole time. That doesn't seem to me, that's not a waiver. It doesn't say, I was looking at all your documents, I don't see anywhere in there that you intended to have this actually count towards the time.
Your Honor, the request for a stay is pursuant to Iowa Code Section 17A.19 sub 5, which uses the words, uses stay as the operative term, in terms of staying the enforcement of the administrative action. Here, the administrative action is tied to the date of conviction, because that's what the legislature unambiguously tied it to. For certain, the district court, the idea that every appellee is going to get a stay is not necessarily guaranteed. And as Justice McDermott pointed out, the Iowa Code 322, Chapter 322 in this operative section was enacted 24 years after Section 17A. And the courts, if you look at Iowa Code Section 322.10, in that licensure statute specifically refers to the 17A appeal rights. So the legislature knew that these rights existed, yet still chose to define the time in which a revocation, it's really a collateral consequence. It's not to think of it as a term of punishment. It's a collateral consequence that for 5 years from the date of conviction, you're unable to participate in a motor vehicle dealership.
Situations with drivers' revocations, which occur quite often. I don't imagine, and you would know better than I do, that if a stay would be granted for a DL revocation, that once the case is over, if the state prevails, if the clock is ticked, they never ever get their ticket punched for driving?
Don't know the answer to that off the top of my head based on the comparable statutory language as to whether it is tied specifically to a date of conviction as this is. But it is, here I think the language is unambiguous as to what is the starting point for the 5 years. If there are no other questions, I'll sit down. Thank you, Your Honors.
Versus DOT is hereby submitted, and court is adjourned for the day.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.